Hi, my name's Louise Merrill. I'm an associate in the employment team at Clarkslegal. This is the 10th and final podcast in Clarkslegal's TUPE in 10 podcast series, and it focuses specifically on commercial contracts in a service provision change context. You'll recall from our early podcasts that there are three types of service provision change under TUPE. Outsourcing, and that's known as a first generation outsourcing, and it's when the client decides to outsource work for the first time to a contractor. There's a change of contractor, and this is known as a second generation outsourcing, and it's when the client decides to change its current provider to a new provider. And there's insourcing, and that's when the client decides to bring services back in-house. Let's consider the type of contracts that might exist in these three scenarios. So in the first generation outsourcing, the client decides to outsource work to a contractor, and we'll call this contractor 1. The client will typically enter into an outsourcing contract with contractor 1 for the provision of services, and that contract will usually have entry provisions covering what happens at the start of the service and exit provisions covering what happens at the end. This situation from a TUPE perspective is relatively straightforward, as the client's the transferor and contractor 1 is the transferee. They're both a party to the contract and they can, in theory, agree terms on TUPE if they wish to do so. Now let's consider the position if the client subsequently changes their contractor, a second generation outsourcing. In this instance, it would be highly unusual for the current contractor, contractor 1, and the new contractor, who we'll call contractor 2, to have a direct contract between them because they're not providing services to each other. Instead, their contracts will usually be with the client. So contractor 1 already has a contract with the client, and the client will now be looking to terminate that, and so the exit provisions in that contract will come into play. The client will also enter into a new contract with contractor 2, and the entry provisions of that contract will come into play at this stage. The difficulty here is that, as we've said, the contract is between the client and the contractors, not between contractor 1 and contractor 2. However, in a TUPE context, the transferor will be contractor 1 and the transferee will be contractor 2. So they can't agree with each other provisions commercially about TUPE, but they may have something in their contracts with the client about TUPE. Finally, what if the client decides to bring the service back in-house? Now, typically here it would just terminate its arrangement with contractor 2 and the exit provisions would be triggered. Again, as the transferor is contractor 2 and the transferee is the client, they can have agreed something in their commercial contract with regards to TUPE. Whichever situation you're in, it's important to remember to check the commercial contract to see if it contains TUPE provisions. TUPE applies as a matter of law and parties cannot contract out of it. However, it's possible for parties to reach agreements on how they'll handle TUPE, which may alter its effects. For example, under TUPE, liability for the transferor's acts largely pass to the transferee, and this will be the case regardless of what the parties contract. However, the transferor may agree to reimburse the transferee for the loss they've suffered, if that's a result of the transferor's actions. So therefore, whilst the transferee remains liable under TUPE, it has a mechanism available to it to recover its financial losses. Let's look at some of the common types of clauses that you might expect to see or want to request, depending on which party you are, in a commercial contract relating to TUPE. Information. TUPE requires the transferor to give the transferee certain information about transferring employees, known as employee liability information. And this information is limited, and it's not really enough to be able to conduct full due diligence and assess risks and liabilities. Therefore, it's common for a transferee to seek more information, and the contract with the client may set this out. Warranties. It's common to seek warranties from other parties to the agreement. A warranty is a statement about a particular state of affairs, and a breach of warranty can give rise to a claim for damages if it's caused quantifiable loss. A party seeking damages for a breach of warranty will be under an obligation to mitigate their losses. So for example, parties may want a warranty that the information provided to them is accurate and up to date. They may also decide how to split responsibility for pay and benefits where the transfer date occurs in the middle of the month, but sums aren't paid until the end of the month, and that may be coupled with a warranty to ensure the parties abide by this. Indemnities. The parties will usually be keen only to accept liability over things they've done and have control over. Under TUPE, the transferee becomes responsible for many of the transferor's acts, and as such it's common for parties to agree that the transferor will provide an indemnity for its pre-transfer acts and the transferee will provide this for its post-transfer acts. An indemnity is a promise to reimburse a party pound for pound for a particular type of liability if it arises. It's generally accepted that, unlike with warranties, there's no obligation to mitigate loss, so indemnities are viewed as being more protective. Under TUPE, liability for failure to inform and consult is joint and several, and so the parties often seek to agree that they shall indemnify the other for any award ordered in relation to failure to inform and consult when that relates to their actions. It's also common for a transferee to seek an indemnity to protect it against employees of the transferor that it wasn't aware of, known as woodwork employees, who may later allege that they should have TUPE'd to the transferee. Where warranties and indemnities are not provided, there may be alternative methods to achieve the same aim, such as an agreement on a pricing change mechanism. Warranties and indemnities should be drafted very carefully, and they can give rise to substantial liabilities, so legal advice should always be sought when you're drafting or negotiating these. Specific issues. If the client or contractor is aware of any specific issue that may expose it to liability, then it may well want to cover this off in a commercial agreement. For example, if during due diligence the transferee becomes aware of equal pay issues, it may want some form of protection in respect of those claims from the transferor, whether this be a warranty, indemnity, or some other method depending on the circumstances. It may also be the case that the parties want to agree matters such as reimbursement of redundancy costs if they know that redundancies will need to take place. TUPE position. Parties may seek to agree a position on TUPE. For example, they may agree that TUPE does not apply to the commencement of the services. And this often helps with commercially with ensuring parties are on the same page and that there's a smooth process. However, it's important to remember that TUPE cannot be contracted out of, and so any agreement like this will not actually change the legal position. If TUPE applies, it applies. So parties seeking to agree an approach contractually need to be mindful of the risks and may want to seek indemnities to protect themselves in the event that the position they've taken is wrong or individuals bring claims. Restrictions on changes. At the start of a contract, if the activities are already being performed by someone, i.e. it's not a brand new service, then a party picking up the service may want to restrict what the current contractor can do with the staff and their terms. And this is to avoid employees being promised things that the new provider has to deliver, or trying to put underperforming employees onto the contracts that they transfer out to the transferee. Obviously, these provisions we've discussed can apply on the commencement of a service, but the contract will also typically have the exit provisions that we've mentioned, which deal with the end of the contract. And these typically reflect those given on entry, but the parties effectively swap positions. For example, a new provider of services may be given more information when it picks up the service, but on exit it will be expected to provide that information to the new provider. There are a lot of matters that parties may want to cover off in the agreement, and it's not possible to go through all of them in this podcast, but hopefully it's given you a taster of the types of considerations parties need to be aware of. TUPE clauses in commercial contracts will need careful consideration and drafting to ensure they cover what's required and offer adequate protection. So this brings us to the end of the podcast and the TUPE in 10 podcast series. We've covered 10 subject areas, each in under 10 minutes, and I hope you found it useful and informative. If you've got any questions on TUPE, please do not hesitate to get in contact with me or a member of the Clarkslegal team. Thanks for listening.